Well, this is the Senate proceedings on this day with regards to the proposed removal from office by impeachment of the governor of Kericho County, that is Dr. Eric Kipkoech Mutai. The county assembly on the 2nd of October resolved to have the governor removed from office by way of impeachment and made their resolution known to the Senate. The Senate opted to undertake or consider this matter by way of plenary. And the process has begun this morning at 10 a.m. What we are seeing now is that the House is going through or still receiving some documents that have been presented by the legal team from the governor's side. Earlier on, the charges were read to the governor, which he pleaded not guilty to all of them. And then we saw the legal team from the governor's side, led by the senior counsel Kato Keegan, also taking the stand to make their statements, opening statements. But there are documents that the senators had indicated that were not in their possession. And the governor's side indicated that the documents are available and can be shared with the members. So that is what we have just seen, the documents being shared for the members to be able to go through and familiarize themselves with the contents of those documents as the presentations continue. Remember, both parties are inside the chambers. That is the party of the side of the governor with his legal team, as well as the side of the county assembly of Kericho County, of course, with its legal team as well. And the process for consideration has already begun. As you can see, members consulting in low tones there, as well as also going through the documents that have been shared by the governor's side. The charges that are facing the governor, that is the governor. He is seated inside the chambers. Of course, throughout this whole process, those two parties will be present inside the chambers until the time of voting, when the Senate will be retreating to make its decision. But throughout all the presentations, both parties will be there. Remember, at this point, both parties will be required to give out their evidence, whether it's witnesses who will be taking the stand, or whether it is a video or audio clips that they would be wishing to play, or whether it's...
Senator Fuller, Senator Sek, Senator Alan Chesang. Now, as we are struggling to restore the system, we are going to use the two microphones, microphones that are placed on the dispatch. So any senator willing to say anything will have to walk to the dispatch and proceed to say whatever they want to state, so that we save on time. We cannot wait until the system is back. Now, I want to believe that all honorable senators have been given the correct bundles. Is that the position, honorable senators? Yes. We do have the correct bundles. Now, as you may have noticed, we have lost considerable amount of time. As Senator Boni has correctly stated, this is a time-bound process. According to our standing orders, we are supposed to give only half an hour to preliminary objections. we have gone beyond that. So I seek your indulgence, honorable senators, so that we move with speed. I will allow the counsel for the governor to proceed and conclude raising his preliminary objection. And thereafter, I will allow the county assembly team to respond. Thereafter, the plenary will have an opportunity to respond or make any intervention or rather debate the preliminary objections as raised by both sides. Counsel for the governor, you had done 10 minutes before the confusion on documentation arose, and therefore you have 20 minutes to conclude.
Thank you, Mr. Speaker, sir. May I first of all thank you, honorable senators, for the accommodation you've extended to me. I appreciate the point made by Honorable Sifuna that I fell below what they have come to expect of me. My profuse apologies. Now, the second order I was referring to is found at page 22 in volume 1, and the effect of that order was that it stopped the county assembly from engaging in discussing and making any resolution on the impeachment. That notwithstanding, they proceeded to engage in discussing it and made the resolution, attendant to which it was forwarded to the Honorable Senate. It is our position that having acted in violation of the court order, the impeachment motion before you within the meaning of the rule of law should not have been forwarded. And the relevant part of that order is order number 5, in which the Senate was told that pending inter partes hearing, the motion dated 1st of October, interim conservatory orders are issued against the respondents jointly and severally, suspending and staying the debating, considering or acting upon the notice tabled on 23rd September 2024, and motion moved on 24th September 2024 for the removal of the applicant governor from office. Those are my first two preliminary objections. Mr. Speaker, sir, I would like to move on to the third preliminary objection, and the third preliminary objection is to the effect, Mr. Speaker, sir, that this motion before you does not meet the 2/3 threshold. Now, Mr. Speaker, sir, the absolute facts upon which I wish to raise that preliminary objection as number one, Mr. Speaker, sir, I know I'm out of time, so I'll be as fast as possible. The first one, honorable senators, is that Kericho County has 47 members of county assembly. And,
honorable members,
yes.
So as we make progress, can we have silence? Please, proceed.
Thank you, Mr. Speaker, sir. The Kericho County has 47 members of county assembly, 30 elected and 17 nominated. Mr. Speaker, sir, all of them are functional in the sense that there is no vacancy and there is no situation where there is any vacancy that is not occupied. Now, Section 33 of the County Governments Act requires that an impeachment motion must master at least 2/3, and I put emphasis on the use of the word at least. Now, for County Assembly of Kericho, constituted of 47 MCAs, that the 2/3 is achieved when the vote comes to 31.3. Thank you. I'm being asked to change the microphones. Now, in the case before you, Mr. Speaker, sir, and honorable senators, the impeachment was passed with a vote of 31 votes. And it is our argument that 31 is not the same as 31.3. If you combine the use of the word at least in Section 33 of the County Governments Act with the threshold being 31.3, when you scale down to 31 as opposed to 31.3, then you have immediately fallen short of the requirement of the statute requiring at least 2/3. Now, 16 of the county assembly members, as per the Hansard which you have been availed, Mr. Speaker, sir, and that Hansard is in volume 1, page 8. page 82 to page 161. Page 82 to 161 contains the answered proceedings of that day. And the significant pages would be page 160 to 161, at which the Speaker of the County Assembly then wrestled with the question whether 31 amounts to 2/3. He then goes on to say at page 160 that my position is fathomed by the fact that we have customarily and by practice since the inception of devolution taken 1/3 of the members of this assembly, that is Kericho Assembly, to be 16, meaning the balance of the members being 2/3 is equivalent to 31. Mr. Speaker, sir, and honorable senators, I will show that on that, the Speaker of the County Assembly was very specifically wrong and misrepresented the facts. Now, Mr. Speaker, sir, having said then that it is only 31 out of 47 who voted.
Senator Manzo and Senator Kajuang, let's hear the council in silence so that we make progress. Please.
With that in place, Mr. Speaker, sir, it is my argument that if the honorable senators were to abstract the argument for one moment, the provisions of Section 33 of the County Governments Act, if they were to abstract and imagine that you draw a line at the point at which 2/3 falls, you would be drawing a line at the point at which you are achieving 31.3. Now, if you come to 31.2 or 31.1 or 31, you have fallen short of the provisions of Section 33 saying it must be at least. It is our argument that this motion could only have succeeded if it had 31.3 and above. When it scaled down to 31, it immediately fell short of the provisions of Section 33 of the County Governments Act and Kericho County Standing Order number 74. Mr. Speaker, sir, I would also want to invite the attention of this Senate to the events that have happened previously in the County Assembly of Kericho. On the 20th of September 2022, as can be seen in volume 1, at page 34 to page 39, at 34 to page 45, an impeachment motion was taken out against the previous sitting governor, and more particularly at page 34, may I make a correction, Mr. Speaker, sir, and honorable senators? The impeachment is at page 34 to page 36, not 37, page 34 to 36. It will be noted that those impeachment proceedings of the honorable previous governor that took place on the 14th May 2024, you will see 14th May 2014, 10 years ago. At paragraph 1, the Honorable Speaker then indicated that I wish to notify the members that there is a constitutional requirement and standing orders that for this motion to pass, there should be 2/3 of the members present in the House. So the clerk, before the motion is moved, kindly confirm that we have 32 members. It is clear 10 years ago that the Kericho County Assembly was very clear in its mind that any impeachment or the threshold of 2/3 requires 32 out of 47. I would like to cite another example that happened 2 years ago, and that is at page 37. And I have particular reference to what is contained at page at page 42 of that bundle. At that page 42, Mr. Speaker, sir, and honorable senators, this was the election of a speaker, but not just any speaker, but this specific speaker, Mr. Speaker, sir. And in that discussion also, whether he could take office or not, it was discussed to this effect when it was being presided by the clerk. The clerk said, "Thank you very much, honorable members. Before we proceed to count the votes, I have very important message to communicate. Please note that the person shall not be elected as a Speaker of the County Assembly unless supported by 2/3 of the members of the County Assembly. 2/3 of 47, we need 32 votes or more. And that if we don't get that, then we'll have to repeat the elections." Mr. Speaker, sir, I would like also to play the audio upon which this specific speaker who presided over these proceedings was elected and which reflects that 32 votes. I request your IT department to play video number 2. That's not video number 2. Video number 2 is with the speaker. I don't know whether they are playing video number 2 of. Yeah, it is a video where the clerk is presiding over the process of elections, and it is the video submitted by the governor as opposed to the video submitted by the county assembly. Video number 2, please. Mr. Speaker, sir, can I proceed and then we come back to the video when it's found so that we save on time? Yes, Mr. Speaker, sir. I'm sorry, Mr. Speaker, sir, I didn't hear you. Yes, he's gone. He's just left. He's just left, Mr. Speaker, sir. Can I argue the other points and then I come back to it? Yes, thank you very much, Mr. Speaker, sir. So apart from relying on those two instances, the 2014 criteria by Kericho County government, determining that 32 is the required threshold to meet 2/3 for purposes of the impeachment of the predecessor of Honorable Dr. Eric Mutai. Apart from that, and apart from the criteria also applied when the current speaker who approved of this motion also said that it was also decided that 32 MCS required to vote in support to amount to 2/3. I wish to make reference also, Mr. Speaker, sir, to the events of the National Assembly. Mr. Speaker, sir, your colleague, the Honorable Mr. Moses Watengula, in a ruling made on 1st of October, and which I pray, Mr. Speaker, sir, you take judicial notice of, and it was in public domain, discussed the issues that had been raised by a number of MPs, being whether 2/3 is mastered by 116 MPs or 117. And the very relevant bit of that situation, Mr. Speaker, sir, and honorable senators, is that in the National Assembly, 1/3 of the total number of members of the National Assembly, being 349, came to 116.33. And so we find similarity with our case being the point 3 in 31.3 is the same as what happened in the National Assembly being 116.3. And the Speaker was very categorical saying that then the 2/3 for purposes of the 1/3 to approve the impeachment motion for the Deputy President would require 117, being that you move a step further. You don't scale down to 116, you scale up to 117. And Mr. Speaker, sir, that ruling by Honorable Moses Watengula is dated 1st of October 2024, and it was in public domain. And we pray, Mr. Speaker, sir, and Honorable Senators, that the criteria used to elect the Speaker, the criteria used to impeach Honorable Chepkoech, the criteria used to consider the impeachment of the Deputy President, I know it hasn't happened, the criteria used to approve the impeachment of the Deputy President at the National Assembly used one formula being that you move a step further because you cannot have a fraction of a person. That criteria should not then change in the case of Eric Mutai and be that you scale down just because it is Eric Mutai. It is our argument that that would be discriminatory. The last incident that I wish to cite is the events of Nyamira County government. In that county government, there are 34 members of county assembly. And out of the 34 members of the Nyamira County Assembly constituted of 15 nominated and 20 elected, the 1/3 was found to be 11.3. We again find the same 31.3, the 0.3 in the case of Nyamira. And in that case, the County Assembly of Nyamira adopted the approach that the 0.3 requires that you scale up to 23 people, as opposed to, 11 people, as opposed to coming back to 10 people. And for that reason, then, Mr. Speaker, sir, I insist that it would be discriminatory to deem the motion that has been brought to this Assembly, to this Senate, as being competent to the extent to which it fell clearly short of 31.3. Mr. Speaker, sir, I am aware that my colleagues are restless to make the argument that this is an issue that does not quite squarely rest on your hands under the provision of Section Rule 30. It is my argument, Mr. Speaker, sir, that it clearly falls within your hands, Mr. Speaker, sir. The said Rule 30 states this, Mr. Speaker, sir, where on a particular question or matter, including but not limited to the question of evidence, materiality, relevance, competency, or admissibility of evidence, any question consequential or incidental thereto, where no provision has been made in the standing orders for or in these rules, the Speaker of the Senate shall rule, and your decision will be final. Mr. Speaker, sir, it is my argument that this is an issue that falls squarely in your hands. It is my argument, Mr. Speaker, sir, that when this Rule 14 and 30 was being enacted, they must have contemplated a situation like this, where you need to make a decision on a matter that, as to the competence of this impeachment motion before the senators, on this question of that is consequential as to whether we should go on or not, and all the related aspects of the competence of this impeachment motion. Mr. Speaker, sir, it is my argument that the Senate, in a certain sense, is on trial. It is on trial as to whether it will maintain the requirements of Section 33 on the at least 2/3 and the attendant aspect of the rule of law flowing from whether or not there is observance of that requirement of at least. Mr. Speaker, sir, I will request for just 7 minutes to play the video to make reference to a decision made by Justice Manani, and which is in volume 1, page 60 to page 78. And in that case, Mr. Speaker, sir, the learned judge said that where the committee requiring a certain threshold, in that case it was 1/3, where they sat over a proceeding that fell short of the 1/3, that is at paragraph 90 onwards, then that page, I said it is page 60 to page 60 to page 87, and in more particular, paragraph 90, which is at page 71. At page 71. Where the judge says it is perhaps also necessary to point out that Standing Order 68, subsection 8, uses mandatory term shall when directing that a DOC committee be set up and should comprise 1/3, and then goes on to say if they do not amount to 1/3, then it doesn't meet the threshold. And Mr. Speaker, sir, it is a very significant point that the learned speaker, or rather the Speaker of the County Assembly of Kericho, used that decision, and you will find his reasoning at page 160 to 161 with reference to that case of Michael Ngaduda versus County Assembly of Tana River, and he goes on to say that you round off. And it is our argument, Mr. Speaker, sir, that when you are rounding off, you can never round off to fall below the line. You can never round off to fall to less than 1/3. And if you are to do that, then you would be acting in contravention of the law. Mr. Speaker, sir, with that said, I would pray now to play that video and request, Mr. Speaker, sir, for 5 minutes for my colleague, Mr. Tonen, just to finalize on that issue, on the preliminary objection. Kindly, Mr. Speaker, sir. My colleague, Mr. Tonen, just to finalize on that issue on the preliminary.
Before we proceed to count the votes, I have a very important message to communicate. Honorable members, please note that a person shall not be elected as Speaker of the County Assembly unless supported by votes of 2/3 of all the members of the County Assembly. 2/3 for us, 47, we need to have 32 votes plus, 32 plus. Now, the candidate who in that ballot receives the highest number of votes and the candidate who in the ballot receives the next highest, in case we don't get the 32, those are the only candidates that we shall go to round 2. Now, when we go to round 2, if they tie, we shall go to round 3. Unless that tie is broken, is when we shall declare the Speaker. Thank you. Now, I will ask the Sergeant at Arms, please open that thing.
I think that's okay,
Our
Mr.
control
Speaker,
sheet is the number of votes first. We want to count the first 47. If they are
Mr. Speaker, sir, that shows the election of the Speaker, who made the arguments that I've just referred to, in which he says, because it's at 1.3, you scale it down, you round it off to the next.
Council for Governor, we've heard the video.
Yes, thank you, Mr. Speaker, sir. Mr. Speaker, sir, then in closing, it is my submission, Mr. Speaker, sir, that there are 2 issues both yourself and this Honorable Senate need to address. The first issue is what is the meaning of at least in the Section 33 of County Government Act. What is the meaning? And when you apply the calculation in respect to Kericho, does it mean 31.3 and above, or it can be scaled down to 31? So the first issue is what is the meaning of at least in Article 33 of the County Government Act, as read together with Standing Order number 74 of Kericho County Assembly Standing Orders. Number 2, the second question, Mr. Speaker, sir, is the question of how do you treat a fraction where it relates to human beings? Are you going to say because it's 0.3, you dismiss it and scale it down to 31, or even 0.3 itself represents a person? And this is very significant, Mr. Speaker, sir. When you look at the situation of these proceedings, being, Mr. Speaker, sir, that there were 47 MCAs in Kericho. 16 said we are not attending, number 1. Number 2, they said we do not support the motion. The other than 31 were present and they supported the motion. Mr. Speaker, sir, following the tradition of both the Senate and the National Assembly, it is always the case that when members have not voted in favor of, it is deemed that that vote was not in favor of. And so the 16 must be treated as having opposed the motion. It cannot be given conjecture that the 0.3 could exist in the 16, Mr. Speaker, sir. It is my argument, therefore, then, Mr. Speaker, sir, that clearly it didn't meet the threshold. And, Mr. Speaker, sir, I wish to say that considering the precedent from your colleague from the National Assembly, we pray that for purposes of consistency, Mr. Speaker, sir, unless you have a very strong reason to disagree with him, you adopt the reasoning he has applied for consistency and clarity of law. And secondly, Mr. Speaker, sir, that if the criteria is used differently from Nyamira, from National Assembly, from the election of the Speaker, from the impeachment of Honorable Chepkoin, then it would amount to discrimination. Mr. Speaker, sir, I had requested for just a little latitude. I had said 5 minutes. Could you allow him just 2 minutes, Mr. Speaker, sir, kindly?
Council, your time is up. Your time is up because you kept repeating yourself. Same arguments in different form. So you may want to rest your PO there. Maybe I need to ask you.
Yes, Mr. Speaker, sir.
In response to the preliminary objection raised by, not really an objection, but a preliminary matter from the County Assembly, you have no problem the affidavit dated the 13th of October 2024 be admitted and be part of the record?
I confirm, Mr. Speaker, sir, that I have no objection, and we have discussed, both of us, and subject to the Senate and you, Mr. Speaker, sir, we were agreed that they accept our replacement documents properly paginated, and we will have no objection to the
the application for, as far as the witness is concerned?
We strongly object, Mr. Speaker, sir. But as I said, we have this restraint of the order, and we want to be very measured not to seem to be violating the order that we already have in our favor.
Council for the County Assembly, you may now proceed to respond to the PO as raised by the Council for the Governor.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The two preliminary objections are opposed by the County Assembly. To that effect, Mr. Speaker, sir, we will be asking you to allow a copy of the replying affidavit to be supplied to senators, because we will be making reference to the same. It is already with the Secretariat and marked as volume 8. If that can happen, Mr. Speaker, sir, with your permission, I could proceed. The two preliminary objections.
Do you have that? Where is it contained?
It is yet to be supplied, but it is with the Secretariat pending your ruling, Mr. Speaker, sir. So we can have that done.
Which affidavit are you referring to, Council?
Volume 8 of the Governor's, of the County Assembly's documents, Volume 8.
Are you referring to the affidavit of 13th of October 2024?
Yes, indeed, Mr. Speaker, sir.
Is it contained in any of the volumes, or it's a standalone?
It's a standalone volume titled Volume 8.
So can the Volume 8 be made
Volume
available
8.
to honorable senators?
Yes.
It's a standalone volume, Volume 8.
I can confirm it is with the Secretariat, Mr. Speaker, sir.
Just,
But I could proceed because I will not be
you may
making
proceed,
reference.
you may proceed.
Thank you. Mr.
Proceed, Council.
We object to the two POs on the ground that the very nature of a PO, Mr. Speaker, sir, and honorable senators, is that it has to be on a pure question of law. What counsel for the governor is inviting you to do at this juncture is to consider matters that are disputed, matters of fact. It is settled law that if an issue is contested, if an issue is in dispute, that can only be determined by way of evidence. When you look at the issue of existence or non-existence of the court orders, the County Assembly has strongly opposed that line of argument and has brought evidence to show that there were not court orders. In fact, the County Assembly is arguing that those court orders are either forged or a manipulation of the judiciary system. That evidence can only be tested if we bring a witness before you to be able to clarify on that issue. That cannot be done by just submissions from the bar. On the issue of whether the motion met the threshold, the 2/3 rule, again, Mr. Speaker, sir, you will note that this is an issue that has been contested. We will be producing evidence before you to indicate indeed that that threshold was met. How then, honorable senators, are you able to make a determination without listening to the evidence, without looking at the materials that both parties are relying on? We submit that the only way to do that is to allow this matter to proceed on merit. Then you can question the validity of a certain fact by cross-examination, by examination in chief, and by questioning the witnesses that will be relying, or rather seeking to produce those particular evidences. I note that Council has sought to rely on Rule 14 and 30 of your rules here to make an assertion that the decision on the two POs lies with the Speaker. We beg to differ, Mr. Speaker, sir, on the following reasons. One is that today the Senate sits not as a legislative house, but a quasi-judicial body. So any decision to be made must be made in your capacity as a quasi-judicial body. So the question then is, who is sitting to hear the matter of impeachment of the governor? Is it the Speaker or is it an individual senator? My submission is that it is the House that is seeking to listen and give a determination on the question of the impeachment of a governor. And judicial authority is usually aimed at settling a dispute between two parties. There are two ways of making that determination. One is on a technicality or on a preliminary basis. Two is through hearing on the merits of the case and making a determination. Either way, that decision can only come from the fact finder, from the judge, from the jury. So the invitation that the Speaker sitting in his capacity as a Speaker can make this determination means that the decision of impeaching the governor or not impeaching a governor shall have been made by the Speaker alone, who does not have the legal mandate to listen individually to an issue pertaining impeachment of a governor. On that basis, then, I invite my learned friend, Mr. Njenga, to take you through the merits of the two objections. Thank you, Mr. Speaker, sir.
Mr. Speaker, honorable members, I'll go straight to the objections because of time. In addition to the argument made by my learned friend, I invite the Honorable House, August House, to consider the import and purport of Rule 2 of the third schedule of the standing orders, which grants express jurisdiction to the Senate on two things: A, to investigate the matter, and two, to make determination on the particulars of the allegations. It is our submission that the power to make the determination, even on issues of law, remains always with the Senate, and it cannot be derogated by the application or by the interpretation of Rule 30. Rule 30 is clear. It's only on admission, competence, and any other issue regarding evidence, but not the competence of the entire motion. I proceed to respond on the question of the court orders that have been referred to by counsel. In making this response, I refer entirely to volume 8, that is the reply in affidavit of the County Assembly. I'll urge 3 quick points on that because of time, so that I can allow my colleague to refer to the last limb of the PO. First, we refer you to paragraph 8 to 13 of that reply in affidavit that speaks to the validity of the orders. The County Assembly position is that those orders are invalid. Those orders cannot be validated in the manner that is provided for by the judiciary. They cannot be validated from the judiciary CTS portal. Once you interrogate them against the practice directions of the High Court and all courts that we have already supplied a copy of, then you'll find that there is no means to verify as a house whether those orders indeed issued from the court. And that you'll find the particulars at paragraph 13. Interestingly, and we have a copy of the said orders, you will see as annexed in our affidavit, you'll see, for example, the first order that purportedly issued on the 2nd of October when the motion was being debated before the House. The parties to that order were the County Assembly and the Speaker of the County Assembly. But it appears that the orders mutated a day after without any reference to the procedure allowed and known to all of us as provided for under Rule 18 of the Mutunga Rules as to how you can amend a petition and amend a motion before the House. So they mutated on the 3rd of October to thereafter bring the Senate and the Speaker of the Senate as parties to the order. How did they mutate? How was Senate and the Speaker brought to the same matter within a day without its participation? You will see that we have referred to the screenshots that made the County Assembly aware of these orders. These orders, the County Assembly has taken the position that it was not served with those orders, and that is paragraph 9 of the reply in affidavit. That's an issue of fact that shall require strict proof. We have not been led to any affidavit of service by counsel as to indicate whether those orders were served. It is straight law that an order that has not been served is inoperative for all intents and purposes, including these proceedings. The orders appear to have been, and I'm referring to page 8 of this volume. If you look at the timestamp on top, they appear to have been circulated as early as 11:50 a.m. But when you go to the CTS portal of the judiciary, the application that yielded these orders was filed at 12:10. So we have a situation, honorable members, where an order issued before even the application was filed. That is for the Senate to consider, and we have escalated that matter as an issue of investigation before the JSC, Judicial Service Commission. We have annexed a letter, a very comprehensive letter, that I do not wish to reiterate its contents on before this House. Secondly, as I finish, without prejudice to those arguments, we have argued, and I want to make reference to paragraph 19 of the reply in affidavit. We have argued on the import of these orders. Are they applicable to the Senate to the intent of stopping the Senate from hearing these particular impeachment proceedings? We have referred to the decision by the Supreme Court in the Justice Kariuki Mache matter. This decision is annexed for the benefit of Senate. It's a decision that I had the pleasure of arguing in the Supreme Court together with Senator Professor Ojenda, who is seated here, where the Supreme Court was quite explicit that a court cannot restrain a constitutional organ that is operating within its time-bound constitutional limits. and that I refer to the holding of the Supreme Court at paragraph 11, which you'll find at page 20 of the volume. The import of that holding to this House is that the two orders referred to by counsel for the county governor cannot serve or cannot have the effect of stopping the proceedings before this House. And finally, as I sit down, this Senate has already taken a position in that matter. I will do nothing more than refer the Senate to page 59. Page 59, this will be the last document I refer to because of time. Yes, I'm actually yielding the floor to my colleague. Page 59 is a position taken by the Senate in these proceedings, in this matter. And the Senate has said, by way of a preliminary objection, that we are not bound by that order. It has told the High Court in no uncertain terms that we are not bound by that order to the extent that it does not comply with the settled jurisprudence by the Supreme Court, which has been followed with approval by the Court of Appeal in the Mwangaza case and in many other cases, including decisions of the Senate, specifically in the Sonko matter and also in the Wambora 2 matter, which decisions are within the House. I yield the floor to my colleague to urge the issue of the threshold, the number threshold. Thank you.
Mr. Speaker, sir, honorable members, for the record, my name is Hilary Kiplangat. I will address the third preliminary objection, which is the question of whether the threshold of 2/3 required by Section 33 of the County Governments Act was met in the impeachment of Governor Honorable Eric Mutai. Mr. Speaker, sir, honorable members, Section 33 of the County Governments Act indeed requires the County Assembly to satisfy a threshold of 2/3 of its members to pass a motion for the impeachment of the governor. The controversy in this case, Honorable Speaker, is that 31 members voted in support of the motion, and in the humble submissions of the Speaker as per the Hansard of that day, that constituted 2/3 of the members of the County Assembly. Mr. Speaker, sir, in his ruling, the Speaker of the County Assembly, in page 131 of volume 1 of our documents, allowed himself to be guided by a decision of the High Court, and that is the case of Michael Justin Ngaduda versus the County Assembly of Tana River and 4 others. KELRC 1605, in which a judge of the High Court by the name Justice Manani had held that when it comes to matters rounding off, one rounds off to the nearest whole number. So, Mr. Speaker, sir, when it came to that determination, the Speaker of the County Assembly was guided by a constitutional position which had been determined by the High Court in that particular case which I have cited. Mr. Speaker, sir, that position that is volume 1 of our documents, page 131, you will find the ruling of the Speaker in which he cited the case of Justin Ngaduda versus the County Assembly of Tana River. Mr. Speaker, sir, the decision of Justice Manani is an application of elementary mathematical rule of rounding off, in which numbers are ordinarily rounded off to the nearest whole number. The same formula, Mr. Speaker, sir, has been applied in various other decisions of courts, and a case in point is the case of Adrian Kamodho Njenga versus Judicial Service Commission, which interrogated the composition of the Supreme Court in compliance with the requirements that no more than 2/3 of the same gender shall be in that appointive position. And in that case, Honorable Speaker, the High Court and the Court of Appeal were very clear that when it comes to rounding off, you round off to the nearest whole number. So the reigning jurisprudence which has been handed down by our courts is that one rounds off to the nearest whole number. In this particular case, honorable members and Mr. Speaker, sir, there are 47 members of the County Assembly of Kericho. To achieve 2/3 of 47, it will give you a number of 31.33. The nearest whole number to 31.33 is 31, not 32. That is in keeping with the jurisprudence which has been settled by our courts. Suffice to note, honorable members and Mr. Speaker, sir, in County Assembly of Kericho, there are 30 electoral wards. Out of the 30 electoral wards, 29 men were elected as MCAs, and 1 woman was elected as a member of the County Assembly. IEBC, in constituting the gender quotas for purposes of nominations, nominated an additional 2 men, making the number to be 31 men against 15 nominated women. Thus, the number of nominated women in the County Assembly is 16. So, 31 men in the wisdom of IEBC, and it is important to note that IEBC is a constitutionally mandated body that can ascertain gender quotas as per the law, and in their wisdom, 2/3 is 31. And that is why at the County Assembly of Kericho today, we have 31 men and 16 women MCAs. Even if we were to convert these figures, Honorable Speaker, to percentages, you will realize that if we were to argue that 32 was 2/3, it would yield a percentage of 68.05%. And in actual sense, 2/3 would be a percentage of 66.67. So you will see that variance even if you convert those figures into percentages. And in any event, honorable members, Mr. Speaker, sir, if one was to argue logically that 2/3 is 32 and 1/3 is 16, we would be having a figure of 48 MCAs in the County Assembly of Kericho, which is not in actual sense the position, because we have 47 members of the County Assembly. So, honorable members, this is a constitutional question which has been settled by the courts in Kenya, and keeping with the doctrine of stare decisis, which provides that bodies adjudicating on disputes which touches on the Constitution or the law are bound by the decision of the High Court or Superior Court. The decision in the case of Ngaduda versus the County Assembly of Tana River, as well as Adrian Njenga Kamodho versus Judicial Service Commission, is binding in this House. It doesn't matter how many times the county assemblies or Parliament has applied a different formula. The only time when this matter has come up for determination is before the High Court, and the High Court has given a finding that you round off to the nearest whole number when you are confronted with an issue which requires numbers to be rounded off. Mr. Speaker, sir, those are our submissions in respect of the third preliminary objection, unless my learned senior, Mr. Bosek, has to add, which you can give him a minute or so.
Clerk, how much time is still available to the County Assembly?
Yes, sir. Just to add a few more points, Mr. Speaker, sir. The answer that we've been supplied by learned friend Katwa Keegan have not been certified and also are not complete. I wish to also point out that when you look at what is purported to be the answered, there is a disclaimer that this electronic version of the official answered report is for information purposes only. A certified version of the report can be obtained from the answered editor. Mr. Speaker, sir, honorable senators, we have not been furnished with any document that shows that the same had been certified by the answered senator. In fact, we are not seeing any input from the answered senator. Having said that, we therefore stand to say that whatever that has been produced purported to be from the Kericho County Assembly, just like the documents which were purported to have been produced from the High Court in form of orders, did not go through the process of certification, and therefore they are of no probative value. And on that basis, we urge the honorable senators to look at them and to also question why council will produce documents which are in themselves self-defeating. I say no more. Thank you, Mr. Speaker, sir, honorable senators.
Thank you. Before I allow senators to make the intervention, Counsel for Governor, you may make your rejoinder.
Thank you very much, Mr. Speaker, sir. The first and the point I really just want to emphasize that for the Honorable Governor, we place a lot of premium on the contention that the 2/3 was not met. And as a starting point in response to what my colleagues have said, Mr. Speaker, sir, it can be taken as an absolute fact that it was actually 31 people who voted, and that that what was required was 31.3. So that it then leaves the question, as we already posed, as to whether when you scale down to 31, and as my learned friend Mr. Hillary has said, you round off to the nearest number, whether you would still be meeting the requirements of Section 33, being at least to that. The second argument I wish to make in response to the arguments is the question of whether this is a question of fact. Mr. Speaker, sir, and honorable senators, they said it is a question of fact. They will call a witness to say this and this, but we are all in agreement on what the bottom lines are. It is governed by Section 33 of County Governments Act. It's governed by Section 74 of Kericho County Government Standing Orders. The county assembly members is 47. Those who voted at 31, the requirements is 31.3. Those are absolute facts which are not in contention, and no witness can change them one way or the other. So then, Mr. Speaker, sir, and honorable senators, the issue is ripe for your determination. It is ripe for your determination as to whether you can scale down 31.3 to 31. My colleague has also said that Mr. Boseka said that the handsets we have relied on have not been certified. We wish to point out, Mr. Speaker, sir, that the handsets on their face say the handsets are for information purposes. And Mr. Speaker, sir, we are happy enough to rely on them to the extent to which they represent information, Mr. Speaker, sir. It is of significance also that they do not deny that those are accurate representation of what happened in the county assembly during the impeachment of the predecessor of Eric, that is Honorable Chepkoin, and they do not contest that that was the criteria used to elect the speaker. Mr. Speaker, sir, then there is the contest about the question of the orders. Mr. Speaker, sir, we take this Senate very seriously, and we cannot possibly have come with forged orders. And we are really, really astounded that advocates of the magnitude and the standing of the county assembly could possibly say that the orders are a forgery. Now, the specific allegation that the orders were not served, Mr. Speaker, sir, volume 2 at page 487 shows that the orders were indeed served, and there's an affidavit of service. You will also see from the Hansard brought by the county assembly that, first of all, the affidavit of service shows the service was effected between 9:10 and 10 o'clock. The voting for purposes of the impeachment was done at 2, as can be seen in the answer that was produced by the county assembly at page 58. If you go at page 160, at page 161, it shows that they completed their process of impeachment at 2:18. So clearly, service was effected long before they did the voting. Mr. Speaker, sir, we stand with the orders. It is also significant that they say there was a forgery, but my very good friend, Mr. Hillary, filed a notice of appointment to come into that case the day after, on the 3rd of October. If they are saying there were no orders, what were they doing getting into that case and participating in that case saying we want to represent the county assembly and challenge the orders obtained? And Mr. Speaker, sir, we take exception at the allegations made about the orders not being proper. Mr. Speaker, sir, with that, I would like to rest my response and request for your indulgence for just 1 minute for my learned friend, Mr. Tonen, to just say one thing, and we rest our case. Kindly, Mr. Speaker, sir.
Honorable Speaker, members of the House, for the record purposes, my name is Tunen Manasseh, and I rise only to respond to one issue, Mr. Speaker, and that is the issue of 2/3, as indicated by my learned colleague, Mr. Hillary. Honorable Speaker, the issue of 2/3 is not a mathematical question in this instance. It is indeed a legal question. And if you take, for instance, Mr. Speaker, that at 31.3, a line of a threshold has been drawn. And the law states, and in mandatory terms, that it should be at least 31.3. That means that you have to scale up the numbers to meet that threshold. Because if you reduce the numbers to 31.1 or 31, that means that you've fallen below the threshold that is provided by law. Mr. Speaker, as you are aware, even in the standing orders of this House, standing order 7 in the election of the Speaker, Mr. Speaker, the House is composed of 67 senators, and 2/3 of that is a decimal point. Mr. Speaker, and as you can recall, on your election, the numbers were scaled up and not scaled down. This means that you do not reduce the number below what the law provides. So, Mr. Speaker, as you rule or as the House debates on that, consider that a 0.3 of a person needs to be completed. You do not negate or remove that particular person. So in our submission, we hold the position that the threshold was not met. Mr. Speaker, and also one issue that Hillary raised, and it was containing the issue of the gender in the County Assembly of Kericho. Honorable Speaker, the issue of gender in the County of Kericho is not the same and is not captured under Section 33 of the County Governments Act. Mr. Speaker, we urge the House to look at what the law provides and if we can scale down to that. And this House, Mr. Speaker, let it not be the House that sets the record or give precedence that you can play with numbers. Let the House be very firm in its decision and uphold the rule of law. That will be all, Honorable Speaker.
Thank you, Counsel for the County Assembly and Counsel for the Governor. Now, I will allow honorable senators to make intervention in this regard. Now, honorable senators, you will notice that this is not the ordinary preliminary objection that we've been dealt with before. It's a preliminary objection that is of a fundamental nature. It may or may not terminate these proceedings. And therefore, as you make your intervention, have that in mind. I will start with Senator Edwin Sifuna.
Honorable Speaker, allow me to put the question to Counsel for the...
Senator for Meru. Certainly you cannot stand on a point of order because I don't see anything disorderly from the Senator for Nairobi. Just take a seat, Senator Sifuna, unless you're seeking for an intervention.
Honorable Speaker, of course, the honorable member for Nairobi, Senator for Nairobi, is quite in order. But I was just seeking one guidance, Mr. Speaker. Also looking at the time, maybe you can guidance on the number of minutes we can take on this, the senators, and also how many minutes can one senator use on the floor, Mr. Speaker.
Honorable senators, if you strictly apply the rules of procedure, then you have 2 minutes. Proceed. And 2 minutes it is.
Thank you, Honorable Speaker. My question goes to Counsel for the Governor. And Honorable Speaker, I would like to refer him to volume 1 of his documents. At page 7, Honorable Speaker, paragraph 20. There is an averment there, Counsel, that has been made by the Governor that in fact there was a holding of the High Court, and this is in reference to Malindi ELRC petition number E006. I don't know if we are together. Counsel, page 7 of the bundle at paragraph 20. Counsel, the volume number 1 of the Governor's bundle, page 7, for heaven's sake, Honorable Speaker, my time is being wasted by things that I've already said.
Just proceed.
Honorable Speaker, I'm referring to bundle, volume 1 of the Governor's
Senator
bundle.
Sifuna, you
at
can
page
only
7.
repeat if I tell you to repeat.
Thank you, Honorable Speaker. Counsel, you have presented the averments at paragraph 20A as a holding of the court, that in fact the paragraphs you have superimposed there were a holding of the court. Now, you are a lawyer of great repute, and reading a judgment you can ascertain what a finding of the court is as opposed to an analysis of the presentations of the parties. Honorable Speaker, the judgment referred to is at page 70 of that same bundle, exhibit number 1. And I want the Counsel for the Governor to confirm to this House that in fact, the paragraph quoted at 20A is not a finding of the court on the question of what 2/3 means and what should happen when there is a decimal. Honorable Speaker, I will refer you to paragraphs. He has quoted from paragraph 83, which cannot be a holding of the court. And in fact, the holding of the court should be at paragraph 86 of that judgment. Honorable Speaker, my question therefore to him is it proper for you to present an analysis of the case by the learned judge as a finding of the court? Honorable Speaker, that is the question I wanted to put to him.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, my comment on this will be limited on what I beg that the House adopts to help this country. This is a very serious matter, and Mr. Speaker, it is already on record that no court can injunct Parliament. So the first PO should collapse. A decision has already been made. My second comment, Mr. Speaker, is on the question of numbers. Kanzo Mutuma, what would you like the governor to prove? It is a scientific fact that 47 divided by 2/3 is 31.3. As you guys say in law, res ipsa loquitur. It proves by itself. What do you want him to prove? It is not possible for a human being, Mr. Speaker, to be a fraction. I want, Mr. Speaker, to urge the Council that because you also have a responsibility to grow the philosophy of impeachments, let us agree that on this one, let us give it to the governor. We give him the fact that a fraction of a human being does not exist. Next time, come with full numbers and we would listen to you. Finally, Mutuma, because you're very experienced in this process, listen to what the Speaker of the National Assembly said about the same thing. The County Assembly of Nyamira said about the same thing. The County Assembly of Kericho about numbers during elections. They have said the same thing. So why do you invite us to disagree with all of them? So as to please you or to allow the proper jurisprudence?
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I just want some clarity from the Council of the Governor. The Council for the Assembly has presented facts that this matter had already been determined by a court. In their Volume 1, page 131, there's a finding of the court that when it comes to the issue of 2/3, it is not an issue where you determine the question of a human being being able to be fractioned, but rather a scientific. Are you then, in your submission, questioning, or rather, have you challenged, or has anyone else challenged that finding of the court in the matter of Michael Justin Dunda with the County Assembly of Tana River? So that is a point that I'd like you to clarify, because this is a finding of the court. Number two on that issue is on the finding on the matter to deal with JSC, where the court, according to the facts presented by the Assembly, stated that you round off to the nearest whole number. What would be the nearest whole number in a matter which is 31.3? Is it 31 or is it 32? Thank you, Mr. Speaker.
Senator Fernandez, Senator Samson Cherangeli.
Mr. Speaker, you need to protect me from the majority leader. Mr. Speaker, I want to agree with my colleagues. Just a quick comment is that in the history of this parliament, no one can injunct parliament. So I think on that aspect of injunction of parliament or court order before the parliament or the Senate, it does not hold water, and therefore I think I would advise the defense team of the governor to stop pursuing that line. Number two, and finally, Mr. Speaker, on the issue of 2/3, Mr. Speaker, my concern is on Section 33 of the County Governments Act and Article 181 on removal of governor. Mr. Speaker, and in the decision of Raila Odinga versus IEBC in 2013, the Supreme Court pronounced itself that when the process, and I want to extrapolate, when the process has taken off and it is time-bound, as envisaged in that ruling before the Supreme Court, that process is time-bound. So by the fact that you read the charges and the process is ongoing, when you look at rule number 16, rule number 14, and rule number 30 on the removal of a governor, the process is already ongoing and the train has left the station. So, Mr. Speaker, the question should be, if the process has already begun, as per Section 33, with the genesis of Article 181 on removal of the governor. Therefore, what happens, Mr. Speaker? I agree that in scientific proof that you cannot have a fraction of a human being. But also, for some of us who are not very good in mathematics, there are also principle of truncation. So, Mr. Speaker, you must balance both so that at the end of the day, we give justice to the county assembly and we give justice to the governor and any other person, including the people of Kericho, Mr. Speaker. So since the train has left the station, let us go ahead and listen to the merits and demerits of the case, and then we determine. I submit, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, the issue of limits of judicial authority on independent institutions has been settled. And I think we have seen some precedents that have been presented to us. Secondly, we need to make a distinction between procedural fairness and procedural technicality. Procedural fairness demands that the governor for Kericho has been accused of gross misconduct, and all sorts of allegations have been made against him. This is his opportunity to defend himself against those allegations. There should be procedural fairness as required in our Constitution. The other aspect is procedural technicality. And Mr. Speaker, you do recall that if we were to be obsessed with procedural technicality, in 1992 it is John Harun Mwau who would have been the president of Kenya, because he went to court and said he's the only one who presented his petition in a foolscap rather than on an A4 paper. Mr. Speaker, the ruling that has been referred to by both parties, we are getting different interpretation. On this matter, we should not go with Rule 30. Rule 30 empowers the Speaker to make a decision. Mr. Speaker, I want to encourage, the way we did in the case of Nairobi Governor Sonko, there were affidavits that were sworn by MCAs that discredited the outcome of the vote. The Speaker ruled that let's allow all parties to prosecute their case, and then the senators sitting as a jury would make a decision on the ultimate day of voting. I would propose and I would urge, Mr. Speaker, that we do not refer to Rule number 30, but allow the House to proceed and ensure that there is procedural fairness in the matter of Kericho.
Senator Kathuri.
Thank you, Honorable Speaker, for this chance of the 2 minutes also to make a comment on this very, very important matter. And Mr. Speaker, as we are here, many Kenyans are watching at us. They are grown on their TVs because, you know, many Kenyans are now sensitive on devolution, sensitive on governance and all these things. So, Mr. Speaker, the PO number 1 is actually dispensed of naturally. So the PO number 2, Mr. Speaker, besides, because that 1.3, the High Court pronounced itself that you go to the nearest whole number. When you go to the nearest whole number, you run at that one, Mr. Speaker. The other argument is about now the direction that has been put in Kericho County when they were electing the Speaker of the County Assembly. So, Mr. Speaker, because this matter is about mathematics, so what I would request, as also other colleagues are putting it, Mr. Speaker, we would like to hear these cases. We give the Kericho County Assembly and the Kericho County Governor time to prosecute their matter before this Senate, Mr. Speaker. Because if we determine this matter in any other way, rather than listening to the parties, then we will not be giving justice to the good people of Kericho and the country at large, Mr. Speaker. So Senate will be a house that cannot be able to protect the devolution, Mr. Speaker. So in my submission, I wish that we are able to listen to both sides, and then we are judges. This is a High Court sitting, Mr. Speaker. We will be able to make our determination in one or the other, Mr. Speaker. Thank you very much.
Senator Wambua.
I thank you, Mr. Speaker. Mr. Speaker, two things. One, I don't know why Senator, my colleague, my friend, Senator Alwale would want to pick and choose on court rulings. A precedent has been set in the court, and he has quoted it, on the matter of separation of powers, that no court can injunct a parliament in its deliberative roles. And so PO number one, everybody agrees it falls on its face. Speaker, then PO number two, you know, what the lawyers on both sides are asking these judges here to do is a very complicated matter. It's a matter of determining a fraction of a human being. What is 0.3 of a human being? Is it still the head? Is it the, what is it? But the Speaker, again, the courts have pronounced themselves on that matter. And in the case of Tana River, they have said that in a matter like this, then you round off to the nearest whole number, which is 31. Mr. Speaker, there are substantive matters for determination in this motion that this House needs to be engaged in. And you ask me, Mr. Speaker, as Senator Cherargei has said, the train has already left the station. We are already in motion. Let us hear this case. Let's make a determination one way or the other. Mr. Speaker, I submit.
Senator Aaron Cheriot.
Thank you, Mr. Speaker. Mr. Speaker, the people of Kericho have quarreled, and we've come before this House to seek for justice. And we pray for nothing less than justice in the interest of the people of Kericho. I want to make two quick observations, Mr. Speaker. One is unanimous by what colleagues have said, that PO number one has been determined by not only by Parliament itself, by none other than the Supreme Court of the Republic of Kenya in Wambora 1, 2015, Mr. Speaker, where it has been firmly established on what you do with a parliamentary process, either in Parliament or at the County Assembly, once an exercise has commenced. Therefore, on that count, Mr. Speaker, I plead that the Council for Governor notices and appreciates that particular issue. Second and most important, Mr. Speaker, is on this issue, and I wish my good friend Senator Boni Halwale listens keenly to this. Mr. Speaker, there is what you call the hierarchy of law, where the Constitution reigns supreme, it sits at the top. And when a matter is not sufficiently addressed in the Constitution, you look for it in statute or legislation that we have passed here. Where there is none, Mr. Speaker, what follows a third after that is already established case law. Mr. Speaker, the Speaker of the County Assembly of Kericho, in his affidavit, and it is hereby presented in volume 8 of the documents from the Assembly, cited court decisions that have been made on this particular issue. Therefore, Mr. Speaker, I don't know on what basis you would want to fault the Assembly, because I have listened to Council for Governor and there is no citation whatsoever on their part other than application of mathematics and this theory that we want to be told that there is no half or quarter of a human being. I thought, Mr. Speaker, that being a house of procedure, we would establish what is a practice that has been established in our courts of law. Mr. Speaker, you know, what I find to be extremely curious, though, is a very dangerous invitation that the Council for Governor is sending out to you. I listened to him, Mr. Speaker, and he wants to lead you to make a decision that has never been made by any other speaker in this House, Mr. Speaker, where he wants you to make a determination on appeal and dismiss this case altogether.
Now, have a seat. Now, honorable senators, it is now 4 minutes past 1. We can only, during a morning session, prosecute business up to 1 p.m. And therefore, allow me to invoke Standing Order 34, 2A, to extend the time for 15 minutes. Thereafter, we shall rise for a break. We'll come back at 2:30 and prosecute this matter because it is of such a fundamental nature. I'll give you 1 minute to conclude.
Mr. Speaker, you are being invited to very dangerous path. Previously, before this House, in Mike Sonko versus County Assembly of Nairobi, and previously also in Ferdinand Waititu versus the County Assembly of Kiambu, such POs have been raised. What did your predecessors do? They let the jury make the determination, which is all the 47 delegations. Do not accept, Mr. Speaker, the invitation that is being passed on to you to make a determination on your own. The Constitution, nor our standing orders or legislation, never envisioned a situation where the Speaker could terminate proceedings such as this, Mr. Speaker, purely on a point of order. Therefore, I want to humbly request you, Mr. Speaker, that just as we do in legislation, let us make a determination on this PO. If it comes to voting, let it be the case, Mr. Speaker. But on your own motion, Mr. Speaker, in the interest of justice for the people of Kericho, allow us to listen to this case and eventually make a determination one way or the other. I thank you.
Senator Mogeni.
Thank you, Mr. Speaker. Mr. Speaker, what I had my classmate, Keegan Katwa, say is to invite you to invoke Standing Order number 30 to make a final determination on this impeachment.
It is the rules of procedure, not standing order.
Okay, yeah, under, I think, the third schedule, under the rules of procedure. Mr. Speaker, my understanding is the moment an impeachment lands on the floor of the Senate, it becomes the property of the jury, who are the senators. If these proceedings were being conducted by a special committee of 11 members, Mr. Speaker, you will never be invited to make a determination on the issue of whether a 2/3 was reached. That decision will be made by that committee of 11. By extension also, Mr. Speaker, the right people, the right person or persons to make a determination as to whether the threshold of 2/3 was reached during impeachment is the House sitting as Senate. I don't think, Mr. Speaker, you'll be setting a right precedent for you to take that power away from the elected senators. Council can invite senators to listen to that issue and make a determination. But I don't think, Mr. Speaker, sir, it is right for you to be asked to make that determination as our Speaker. And I agree with those who have spoken before me, Mr. Speaker, that precedent has been set. During the Sonko hearing, Mr. Speaker, similar matters arose before us, Mr. Speaker, on issues of quorum. But the Speaker then ruled that those issues be argued as part of the defense of Governor Sonko. And then the senators make a determination. I invite you to be extremely reluctant, Mr. Speaker, to take a seat where you will be sitting as a jury and making a determination to either acquit or convict the governor for Kericho. That is a mandate reserved for us senators.
Senator Robo.
Thank you very much, Mr. Speaker. Listening to both sides, there's an alleged evidence by court ruling that has been shared by the Counsel for the Governor, but the citation of court rulings shared by the Counsel for the County Assembly. Mr. Speaker, sir, as shared by my colleagues, there is a question of common practice globally, and the issue that deals with the issue of fraction. And then there is the law. And the matter before us is not an easy matter that can be prosecuted
by making a simple decision of, for example, what you have been requested in the preliminary objection to make, that of maybe, in the words of the counsel for the governor, to, on the basis of just the argument of the threshold, determine that there is no case to be heard by this Senate. It is important that Senate sitting as a jury and a quasi-judicial setting to make that decision themselves, so that it also becomes other precedent-setting cases, as mentioned by various colleagues of mine in the House, of cases, governors appearing before the same Senate. Can you allow this Senate to make that decision by way of voting, so that it becomes also another precedent-setting rule, rather than taking the burden of making a decision that the people of Kericho are expecting, the issue before the Senate to be really listened to and adjudicated over by the entire Senate as to.
Senator Muma.
Thank you, Honorable Speaker, for giving me an opportunity to contribute to this. Honorable Speaker, I wish to support sentiments by previous speakers, but wish to point out a very important issue when it comes to the PO on the threshold. Mr. Speaker, I want to point out that in the past, when the threshold has been about gender, the math to surround it, to round off to below the figure has sufficed. An example, a point to demonstrate this is the very county assembly of Kericho. So I wish to call upon our colleagues to take note that the Kericho County Assembly has 47 members, only 16 are women. So even as you make a decision, depending on what decision you make, we may have to nominate one more. I also wish to point out that in the bundle of evidence by the governor's team, that they indicate that the speaker was appointed by 31 votes to 16. It is something you need to take note of. And thirdly, to take note of that the Supreme Court of Kenya was not nullified, the first Supreme Court, on the basis of the 2/3 gender rule. In fact, it was rounded off and actually allowed to sit, even though it had not reached the threshold of 2/3 gender. So please consider all these, and let's not be, when it is a gender issue, we conveniently can round it off the other way, but not on the other.
Senator Newton.
Thank you, Mr. Speaker. I also stand to give my contribution to the effect that, as all those that have spoken before me have said, that the matter, the number one, has already been settled, and I need not address it, Mr. Speaker. Mr. Speaker, about rounding off numbers, this is something that we were taught in the first lessons of numeracy when we went to school. And it is obvious, Mr. Speaker, unless our teachers were very wrong, that we round off to the nearest number. And so, Mr. Speaker, 31.3 can only be rounded off to 31. And so, Mr. Speaker, I support the argument by the Council for the Assembly that then the Assembly was properly constituted, Mr. Speaker. Mr. Speaker, I would want to ask this House not to be invited to an exercise of splitting hairs. We should not be sitting here arguing whether we should round off to the nearest number or not, because that is something, like I've said, that was sorted out many, many years ago during our numeracy lessons, Mr. Speaker. Mr. Speaker, the issue of validity of the court orders that were issued and that have been cited by the Council for the Governor Mr. Speaker, the validity has been questioned. And I do not know what then should be done before you make a ruling. But Mr. Speaker, this matter is before the Senate. And like those that have spoken before me have said, it is only this House that can determine whether we are going to admit these preliminary objections and not you, Mr. Speaker. And so I may want to ask you that you may rule that at the end of it, that we may vote on this matter so that we as senators, the members of this jury, may decide whether, by a vote, whether this matter should proceed or not. Mr. Speaker, please don't allow yourself to be the one making this decision, because if it were a committee, like Senator Mogeni has said, Mr. Speaker, you would not be sitting there. This
Now, honorable senators, it is now 1:15, and having concluded the business for which I extended the hours of sitting, pursuant to Standing Order 34-2A, the Senate stands adjourned until today, 14th of October 2024 at 2:30 p.m.